Welcome to The Debate. Today we're tackling something really fundamental to American governance, the U.S. Constitution's core design principle. Is it fundamentally built for rigid stability, for constraint, or is its real strength actually in its, continuous flexibility and adaptation?
Right. And the specific question we're digging into is this. Does that really tough amendment process in Article 5, along with its explicit limits, mean the Constitution is mainly a fixed, stable document?
Or alternatively, do all of these necessary, ongoing debates we see over things like executive power, judicial interpretation, show that its primary function is actually, adaptable and evolutionary?
I'll be arguing that the structure itself prioritizes constraint and rigidity, really meant to bind future generations. And I'll argue that, while Article 5 is definitely a high bar, the sheer complexity of modern life requires the Constitution to function through flexibility and interpretation. It's a necessary reality, meaning the document is maybe defined more by how it evolves than just its original fixed text.
Look, the Constitution is, I think, fundamentally a contract of restraint. It was deliberately engineered to make structural change incredibly difficult. Why? To prevent the concentration of unchecked power. And to really grasp this, we have to look squarely at Article 5. The framers set up this tremendously high threshold for any formal change. You need a proposal by 2/3 of both houses or 2/3 of the several states, and then ratification by 3/4 of the states. That's not just a hurdle, it's a structural barrier. It's meant to anchor the core balances of power against, the temporary passions of the moment, the fleeting majorities. But maybe the most powerful piece of evidence for this commitment to rigidity is actually baked right into Article 5 itself. It's that unamendable restriction, the clause saying, and I quote, "No state, without its consent, shall be deprived of its equal suffrage in the Senate." That's kind of the sacred geometry of the Republic, right? It's an absolute permanent lock. It really proves the founders were committed to defining boundaries that just cannot be crossed. Ensuring state sovereignty, a core balance, could never just be voted away, no matter what future political pressures or perceived national needs might arise. I see why you might think interpretation makes it flexible, but the structure itself is designed to ensure power stays contained within these defined enduring limits.
Okay, I appreciate the focus on the structure, I really do. But I think that kind of misses the forest for the trees in a way. While I absolutely acknowledge the significance, the solemnity of Article 5, the sheer everyday necessity of interpreting vast areas where the Constitution is silent proves, I think, that it has to be fundamentally flexible just to survive and function in the modern world. If the text were genuinely fixed, only operating within those explicit textual limits you mentioned, how could our government even operate today? Especially when core presidential authority often rests on evolving non-textual practices. Just take executive orders. We all know these written directives carry, much of the same practical weight as federal law. Yet their use, their legal standing, it's nowhere explicitly defined in the Constitution. Their actual authority rests almost entirely on historical practice, executive interpretations, and then court decisions that adapt the general idea of executive power to what's needed now. If the Constitution were truly as rigid as you suggest, the core authority of the presidency, which, let's face it, is often the branch that needs to respond most quickly, it just wouldn't rely on such dynamically evolving foundations. This gap, this space between the explicit text and the practical function, it really demonstrates that the document's long-term survival hinges on its adaptability. The lack of explicit definition, far from proving rigidity, is actually what allows the whole framework to survive in an era the founders couldn't possibly have imagined.
But hang on a second. If we allow historical practice to, in effect, amend the Constitution, doesn't that sort of render Article V, not useless, but significantly weakened? If core, almost legislative powers like issuing executive orders can just develop through custom and interpretation, it seems to undermine the very mechanism the founders carefully put in place to limit power. We know from figures like Gouverneur Morris, the person who actually drafted the final language, that the whole constitutional project was focused on preventing the easy accumulation of centralized power, on limiting the tyranny of the majority. If judicial and executive practice can just sort of override the need for formal amendment, then that fixed structure is eroded, isn't it? And the foundational commitment to limited government starts to look a bit shaky?
That's a compelling point, rooted in constitutional theory. I get that. But the reality of actually governing seems to demand a different approach. These debates we see about the legitimacy of executive orders, like, for instance, disputes over whether a president can refuse to spend funds Congress approved, the whole impoundment issue, they exist precisely because the original text is either silent or just requires significant expansion to address the unforeseen complexities of a massive modern administrative state. The text's silence doesn't prove rigidity to me. It proves the necessity of political and legal evolution to fill those functional gaps.
Okay.
And furthermore, even when the text is explicit, interpretation is still absolutely essential. Think about the 14th Amendment Citizenships Clause. All persons born or naturalized in the United States are citizens. Seems pretty clear, right? Yet its actual scope still requires major contested debate. Consider that landmark 1898 Supreme Court case, United States versus Wong Kim Ark. The court had to interpret whether that clause applied to the children of non-citizens born here. That wasn't just a mechanical application of plain words. It was a profound act of interpretation, looking at historical context, trying to divine intent regarding sovereignty, basically defining the scope of American citizenship for well over a century. So textual clarity is often just a starting point. The ongoing debate proves that meaning demands interpretation to stay relevant across wildly different historical periods. And let's maybe expand on this idea of dynamic application. The constitutional framework, I'd argue, is only functional today in the 21st century because its spirit allows for flexibility. It has to accommodate massive societal shifts the founders just couldn't have possibly foreseen.
But is that flexibility inherent, or is it imposed?
Well, we see it playing out daily in the Supreme Court, right? Look at the incredibly complex legal issues that constantly come up. The courts are forced to grapple with highly specific, modern questions. Things like the limits of state laws on gender-affirming care for teenagers, or complex reverse sexual orientation discrimination lawsuits involving private companies. These very nuanced issues demand extensive, current judicial interpretation. They require reading foundational concepts like due process or equal protection into completely new contexts, like digital privacy or medical autonomy. That, to me, proves the Constitution is a dynamic framework. It's designed for continuous, functional evolution. It's more like a template for dialogue than a fixed rulebook. It's a document that somehow has to stretch to cover things like satellite communications, nuclear power, the internet, none of which existed when the ink was drying on the parchment.
I'm just not convinced by that line of reasoning, because I think it profoundly confuses the necessary function of judicial review with some kind of inherent structural flexibility. The need for the Supreme Court to wrestle with these incredibly nuanced modern cases, that's actually evidence, I think, that the core text's limitations are being tested by new situations, by novel facts.
Tested, yes, but then adapted.
While the judicial branch's role isn't really to grant the document flexibility, its role is to interpret the fixed constraints of the text and essentially hold the line against new legislative or executive attempts to overstep those boundaries. When the court considers a difficult question, like say the gender-affirming care example, it's ultimately asking, does this specific law violate the original fixed promise of equal protection? It forces a return to foundational principles. It's not really a celebration of the text's pliability. The Constitution, I maintain, mandates structural stability. And it's that difficult amendment process which forces a really broad, almost unanimous consensus that anchors the structure against temporary political wins that might otherwise allow current majorities to constantly redefine essential liberties or the fundamental relationships within the government.
But the rigidity you're championing, it has demonstrably failed to maintain stability in the past, hasn't it? I mean, we often celebrate the Constitution's longevity, but that longevity was arguably bought at a terrible price. The structural rigidity embedded in the original text, particularly around slavery and state power, led directly to massive civil and political crises, the most obvious being the Civil War. That conflict and the Reconstruction amendments that followed, the 13th, 14th, and 15th, those weren't gentle evolutionary steps. They were radical structural reinterpretations forced onto the nation precisely because the original fixed document was incapable of adapting to the profound moral and political need to abolish slavery and properly define citizenship. The Constitution only survived because it underwent a period of massive, politically painful, frankly violent flexibility. In that instance, the rigidity proved to be the source of profound instability, not stability.
That's a powerful historical point, certainly. But I think it actually underscores my argument about the purpose of the fixed structure. The Civil War, one could argue, was a failure of political will and compromise, maybe not strictly a failure of the constitutional design itself. And crucially, once that crisis was resolved, at immense cost, as you say, the resulting changes were enshrined permanently through Article 5. That process itself proves that when the nation makes fundamental structural changes, they are done through that arduous, definitive mechanism of amendment, which is exactly how the founders intended to safeguard such core alterations.
Locking them in after the fact.
Exactly. And we can't just dismiss the structural weight of the unchangeable provisions. Let me just reiterate the most powerful example, that permanent prohibition against depriving any state of its equal suffrage in the Senate without its consent. This clause, sitting right there in Article 5, shows that the founders established at least one boundary that is absolutely fixed. It's immune to interpretation, immune to amendment. This fixed status demonstrates, I think, that the ultimate intent was structural permanence and the protection of state status, regardless of whatever future needs might arise. At its very core, the Constitution is a contract built on enduring structural limits.
Okay, I readily acknowledge the equal suffrage clause. It is a profoundly powerful structural limit, no question. It stands as this unique testament to the difficult compromises needed just to form the Union in the first place. However, outside of that single specific exception, the Constitution seems overwhelmingly defined by its ability to evolve through political practice, through judicial review, particularly because so much of its foundational language is necessarily broad.
Broad, but with intended limits.
Perhaps, but the very fact that these constitutional topics, things like the founders' actual views on the separation of church and state, or the legacy of key figures like John Adams, remain active subjects of modern education, modern debate, that shows the framework is perpetually being redefined by dialogue, by context, not just by the original written constraints. The Constitution survives because it can hold and accommodate these ongoing, often fierce debates about its own history and how it applies today. If it were truly as rigid as you portray it, those profound political and moral arguments would have likely fractured it centuries ago or simply faded into irrelevance. It feels much more like a living, functional framework that actually demands flexibility to maintain its relevance over time.
So when I step back and look at this whole discussion, my core conviction really remains unchanged. The fundamental genius of the Constitution lies in its, yes, rigid structure and that deliberately difficult amendment process in Article 5. This rigidity isn't a flaw, it's the necessary protective layer. It ensures that temporary majorities can't just easily undermine the foundational balance of powers or individual liberties or the established relationship between the states and the federal government. Stability and constraint, those are the primary intentions woven into the structure, and they provide the anchor that allows the system, however imperfectly, to endure.
And conversely, my argument is that the evidence from how executive power actually functions to the constant need for the judiciary to interpret core rights like the 14th Amendment in new context proves that the Constitution's long-term utility stems directly from its capacity for flexibility and adaptation. The complexity of modern governance simply demands it. The document is defined by its ability to stretch, to speak to questions the founders never could have dreamed of, like, privacy in the digital age. Without this capacity for functional evolution through interpretation and practice, the document, I fear, would have become a historical artifact long ago, not the basis for a functioning government.
Well, this tension, this sort of necessary friction between rigidity and flexibility, that's ultimately what defines American constitutionalism, isn't it? And perhaps what keeps it relevant, albeit contentiously, in the 21st century?
Indeed.
And it's precisely this core tension, I think, that gives listeners plenty of rich material for further thought, especially when considering the ongoing dynamics of power, constraint, and adaptation within our constitutional framework.